All right, ladies and gentlemen, a very good afternoon and happy new year. Receive warm greetings from the chilly city of Arusha. It's a pleasure to have you. My name is Gabriel Achaye, and I'm speaking with you right here from the East Africa Law Society House in Arusha, Tanzania. Welcome to this webinar on the critical role of advocates in personal data protection and privacy. And today we'll be navigating the legal, ethical, and regulatory challenges in Eastern Africa. Now, like you all know, with the increasing digital world, the role of advocates in safeguarding personal data and privacy is more important than ever. Today, our panelists will explore legal, ethical, and regulatory challenges advocates face in East Africa as they navigate the evolving data protection laws. We are honored to have an esteemed panel of experts with us, and they will share with us their insights on this very critical topic. We really hope that you find today's discussion valuable and thought provoking, and we would like to thank you once again for joining in on time, and we want to thank our partners from Hilton Attorneys in Tanzania for co-organizing this with us. And for you, our esteemed panelists, it's a profound honor to have you on this session. We look forward to tapping into your wells of wisdom as we delve in this subject. Ladies and gentlemen, our session this afternoon is being moderated by the one and only Dorothy Ndazi. Dorothy is a partner and head of telecommunications, media, and technology at the Hilton Law Group and the legal regulatory compliance head at Green Telecom Limited. She's an experienced legal practitioner specializing in data protection and privacy law, technology, media, and telecommunications, fintech, labor law, oil and gas, emerging technologies, and regulatory compliance. Her deep understanding of legal and regulatory frameworks has made her a trusted advisor to prominent organizations across various industries. She has advised top organizations on data privacy compliance, developed frameworks for safeguarding personal data, and drafted and negotiated contracts for technology providers and digital transformation projects. Dorothy is actively involved in awareness raising of Tanzania new data protection law in collaboration with the Personal Data Protection Commission. She also has conducted a number of trainings on the new law to different organizations in Tanzania. Dorothy has provided strategic guidance on digital rights litigation. She supported telecom and tech firms with regulatory requirements and trained HR managers, legal teams, private school owners, and she has presented a number of papers on Tanzania's status in fintech and labor law at multinational forums. And she has coordinated the East Africa Law Society Committee on Oil and Gas. She's a member of the Tanganyika Law Society, the East African Law Society, Tanzania Women CEOs Roundtable, Adam Global, and a host of many others. And particularly today, Dorothy, we are honored to have you as our moderator, and you can now take on the discussion from this point. Thank you.
All right. Um, Good afternoon, everybody. Good afternoon, everybody. Thank you so much, Gabriel, for a perfect and wonderful introduction. Um, Without wasting much of your time, let us go straight to the topic that we have today and to the discussion that I believe is very important, and we're going to have valuable takeaways from it on the critical role of advocates in personal data protection and privacy, where we're going to navigate on the legal, ethical, and regulatory challenges in East Africa. As Gabriel said earlier, in today's digital age, personal data is more valuable than ever, from financial transactions to social media activities. We have businesses now, governments and individuals, which are now constantly generating, processing, and sharing vast amount of data. We're all a witness to that. With this, there is a need, a very critical one, to have strong legal frameworks, to have ethical considerations, and to have regulatory oversight so as to protect individuals' rights and to ensure responsible data handling. We all know that advocates play a pivotal role in shaping the data protection landscape, whether it's through advising clients, representing them in data breaches cases, or influencing policy and regulatory developments. However, in East Africa, as it is the context today, we're facing some unique challenges in achieving effective data protection. This varies from having varying legal frameworks across the countries to enforcement gaps and emerging technology risks. So today, I'm very glad to host an esteemed panel of legal experts across the region who will help us to navigate these complex issues in their respective jurisdictions. So as we dive into this discussion, I encourage all of us to participate and to engage, ask questions, and contribute to this vital conversation so that together we can work towards a stronger and more harmonized approach to data protection in East Africa. And to begin with, let us hear from our first speaker, Ms. Susan Nalima, who is a managing partner at Hilton Law Group in Tanzania, and she's going to discuss on an overview of data protection and privacy laws in East Africa. Welcome, Ms. Susan.
Thank you, Dorothy, for the introduction. Good evening, ladies and gentlemen. Thank you for joining us today for this webinar. I'm trying to see if I can share my screen. Okay. I'm trying to see if I can share my screen, but I'm failing. Dorothy, can you help me share the screen, please? My presentation, sorry. Okay, as we wait for the presentation to be shared today, I'm here to just go through the overview of data protection in East Africa. And I have a few slides to share with you. And as we start, question comes to mind, like reminding us of what data protection is. So when we speak of data protection, what do we mean when you say data protection? And when you read through across the legislations, what you derive from the legislations, it's data protection is legal and regulatory framework that governs collection, storage, and the use of personal information. And what is this personal information we are talking about? So this is basically an information that identifies you as a person. Okay, let me just see. I'll have to share this. Okay, so we are discussing about data protection and what it means. Simply, it's a legal framework and regulatory framework that governs your data as a person or personal information, how it is stored, how it is collected, and how it's going to be used. Okay, so it ensures individuals' private rights are respected when you have a legal framework and regulatory framework in place. And then why do privacy laws matter in East Africa? Why do privacy laws matter? The first is privacy laws matter because they protect sensitive personal information. we as humans, we have an inherent nature of wanting to protect our personal information at any point. We wouldn't want to be monitored. We wouldn't want to be surveilled by anyone when it comes to our privacy. So that is why we need privacy laws in place to actually safeguard that information that we don't want to go out there. This is why privacy laws matter in East Africa. And then we also have an aspect of economic benefits. Privacy law matters because of economic benefits. In a recent webinar that we discussed during the webinar breakfast organized by CS Africa Academy in partnership with Interactive, Real Interactive, we were discussing about how customers alienate themselves from companies that do not comply with privacy laws, essentially. And we saw one of the surveys that was done by PwC in 2022, where they say that 77% of customers actually would get away from your company because you're not complying with privacy laws, and they would go to your competitors. So this is why privacy law matters. Once you earn the trust and the loyalty of the customers, then there is an economic benefit to you. But once you do not comply to the privacy laws, then they will tend to alienate from you, and that will be an economic risk to your business. Okay. And then the other issue of why privacy law matters and why we are discussing all this today is because of the regulatory transparency. Privacy laws will ensure that there is transparency in the way that data is collected, because when you are collecting data from me, I must know, why are you collecting my personal data? What is the reason? Why? How are you going to use it? And when you're sharing, how are you going to share it? Will it be protected while you're sharing it? So once you have these laws in place, the privacy laws in place, it gives that weight to the way the data will be processed in a transparent manner, essentially. And then it also breeds an accountability culture. When we have strict laws in place, privacy laws in place specifically in this matter, when we have such laws in place, we breed accountability nature or culture in a specific area or specific country. Okay. If I know that the laws are there and we have fines, for example, in the data protection, personal data protection laws in Tanzania, the fines include monetary fines and imprisonment. So much as it creates fear, but at the end of the day, it breeds the accountability culture. It breeds the responsibility culture in you to know that, oh, I must safeguard information of the data subjects, so the people I collect information from, or I must comply with the laws of the country, because if I do not, then I'm either going to end up in fines or I'm going to end up in prison. So this is why privacy law matters, basically to protect sensitive personal information, and because we as humans, we have the inherent nature of not wanting to be monitored or surveilled. And then secondly, it's for economic benefits. Thirdly, it's regulatory transparency. How will you store that information? I mean, how will you share that information? How will you collect it? What are you going to use it for? And then fourthly is the accountability nature is instilled in us once we have these laws in place. Then when we look at the East African context in data protection law in East Africa is governed by individual country legislations. So we have Kenya, it has its own data protection law. We have Uganda, Rwanda, and Tanzania. These countries have already enacted their independent laws that govern data protection and privacy. And then another context is the alignment with international standards, and the laws emphasize some key principles. When you read through all those laws that are the laws of the member states that I've spoken about, they all have elements of international standards, and they have some key principles like transparency, rights of data subjects, rights of data subjects, and many more principles like lawfulness and they also ensure compliance with the global norms. Okay. And then the next one is the laws are overseen by dedicated regulatory authorities. So when we look at Kenya, Tanzania, when we look at Uganda and Rwanda, they have those regulatory bodies that are already dedicated just to oversee the compliance and investigation, of course, compliance of the data privacy laws. And they also do investigations when there are complaints that are lodged. Okay. So this is the East African context in data protection. And then when it comes to the digital landscape, still under the same context, we see that there's a rapid growth in mobile phone penetration. And the statistics say that Kenya actually, mobile penetration in Kenya is 100%, in Tanzania it's 99%, and in Uganda is 67.7% as of 2024. So with the mobile penetration and also with the increased use of online services where data flow is exchanged in very many ways that it cannot be controllable, we really need a stronger data privacy law, or we need data privacy laws that are strong and strict to protect this kind of transaction in this digital era. So what is the regional framework in East Africa? We have the East African Community, of course, that was established in 2000 to enhance the regional integration. And members, it is said that members are working towards creating common regulatory framework for the data protection. The East African Community has also realized the accelerating digital transformation landscape, and they're coming up with a framework that will harmonize these laws. So whether it's going to be a challenge or not, but it's in progress. And initiatives, of course, include the guidelines for member states to implement data privacy standard uniformly. So they are looking at a place whereby all the data privacy laws will be uniform across the member states. Then the East African country-specific laws is something that I need to mention during in this overview discussion. And we have already, I talked about Kenya, the Data Protection Act of Kenya that was established in 2019. And the main key provisions in this law is the rights of data subjects. They have an aspect of consent, the right to access, and the right to erasure. That is in respect of rights of data subjects. They also have a dedicated regulatory authority, as already said. And then in Uganda, I'm sure the different panelists will discuss this in depth, but I'm just going through them as an overview. But in Uganda, the law was also enacted in 2019, and it sets out principles for data processing, rights of data subjects, and obligations of data controllers. And they also have a dedicated regulatory authority in that respect. We also see the Tanzanian Personal Data Protection Act that came into force in 2023. And the key provisions there include data subjects' rights, lawful and fair processing, data minimization. And they also have a dedicated commission, which is the regulatory authority that oversees the data privacy laws and protection. And then we have data protection law in Rwanda, which has been said to be very comprehensive. I looked at it, and actually it has interpretation in 3 languages. Yeah, so, and it's been said that the Rwandan data protection law aligns more with the global standards, much as all of them do align, but it's said that Rwandan data protection law aligns more than any other. And they also emphasize data subject rights, accountability, and the role of the Rwandan Data Protection Authority in oversight. Then the current status, which will be confirmed by the upcoming panelists, especially from Burundi, is that there is limited formal data protection regulations in place for Burundi as a member state and South Sudan. Though South Sudan, there's a bill that is upcoming, but we've not heard anything from Burundi. One of the panelists will enlighten more on that, on where they are. And then, of course, initiatives are needed to draft and enact data protection laws to safeguard the citizens' privacy. We all understand there's a lot of data movement or data flow through the member states in East Africa. So without the data privacy laws that governs each country or a harmonized one, then we are treading on dangerous grounds in this digital era. So what are the common principles that are across all the legislations? When you look at all the 4 legislations that are dedicated for privacy laws in the East African member states, one of the components we have is the consent. And by consent, I mean that if you are collecting any data from a data subject is the person you're getting information from. They need to consent if you're collecting that data, and they need to consent that you are collecting their data. And this is an aspect that cuts across all the legislations in East Africa. And then there's purpose limitation. You collect data limited to the purpose for which it's processed. If you're collecting my data for, let's say, payroll, then I have consented that you are collecting it for payroll, then you need to limit it to only payroll, okay? So the next one is data minimization. It also cuts across all legislations. Organizations should only collect personal data that is necessary. For example, if I go to the hospital and I want to be diagnosed, and when the ladies or the whoever, the receptionist, when they're getting all that information from you, at times they usually, like here, they usually ask you for your tribe. So we feel that that data is unnecessary because you are not going to diagnose me by knowing which tribe I am. So data should be minimized to only that which is necessary. And it's from some researches that we read, we've seen that hackers actually, when they're mapping out entities or organizations to hack, they look for organizations that have too much information that is just laying there. So you find yourself, you've collected too much information that is necessary, you have it, but when hackers are mapping, you'll be one of the targets, okay? So another principle is rights of data subjects. It cuts across all of legislations in East Africa. Of course, right to access. The data subjects have the right to access the information. There's right to rectification. If I see there's an error in my information, I have a right to ask whoever's collected it to rectify it. And then there's a right to erasure. If I want it to be deleted at any one point, then as a data subject, you have to delete that information if I ask you to delete it as a data subject. Then there's also a right to data portability, which is across all the legislations. Individuals have the right to obtain their personal data and reuse it across different services. So I have a right to come to you and ask you for my data, and I take it to use it for any other service that I want to engage in. And then we have enforcement and compliance in regulatory authorities. So the various countries, the member states, have established independent regulatory bodies. We've already talked about this. And of course, the countries that have independent regulatory bodies are Kenya, Tanzania, Uganda, and South Sudan. And then we have compliance challenges, lack of awareness and understanding of data protection laws among businesses. We've been trying to go around to sensitize businesses about data protection, and yes, there's a lot of lack of awareness. And of course, we cannot erase the fact that data protection and privacy concept is new in East Africa. But that is something that we have to work on as member states to see that there's a lot of campaigns to create awareness, because it's a compliance challenge. People would want to comply, of course, but they don't know the fines, they don't know about the imprisonment, they don't know about registration, they just don't know about anything to do with data protection and data privacy. And then insufficient resources within regulatory authorities in the East Africa to effectively monitor compliance and enforce laws. So I'm sure we are speaking to advocates. It's not only the role of the Commission to effectively monitor compliance and enforce the law. We cannot enforce the law, but we can assist to lift the burden of the regulatory authorities from the member states as advocates to put up campaigns to sensitize the public, to sensitize our clients. We can start with our clients. I've seen some advocates have already started training their clients, and activities like that is what, in the end, will bring awareness to all the public and to everyone that is concerned about data protection and privacy. So when you
Sorry, Susan. That was a very good introduction and a very well elaborated overview of data protection laws in East Africa. But I wanted to pause you for a moment so that at least we get an insight of the legal and regulatory framework governing data protection in Uganda, and the role of technology and innovation in data protection from Mr. Ivan Ojakol, who is a partner at Matrix Advocates in Uganda. Then we'll come back to you later. Welcome, Mr. Ivan. I can give you like 10 minutes to dive into this, and then we'll go back with we'll proceed with something else.
Thank you very much, Dorothy. I hope you can hear me.
Yes.
Unfortunately, I won't be sharing my screen. Sorry, my video, because I think of I'm not sure of the internet where I am. Hopefully, the audio will suffice. Yeah. So anyway, like Susan in her presentation, Masquerita was mentioned. Uganda, Kenya, Tanzania, Rwanda. We shall find out from Burundi whether they have one now, a data protection law, and of course, South Sudan, I do not think has one in the offing yet. Has similar, the Data Protection Act of Uganda, or the legal regime, has similar provisions, or even many of the provisions that Susan has talked about, and it is a law of 2019 that came into force in 2019, and the regulations there too were enacted to operationalize the act in 2021. Yeah, like I mentioned, the same principles really, from the principles of data protection. Of course, a lot of these couched in constitutional foundations, right to privacy, among others, in Uganda's constitution, which I believe is also similar to many West African countries. Concepts like data processing, data collection, sensitive personal data, international data transfers, data retention, personal data, among others, are already captured in the act. And I don't want to bore our listeners or audience by going to the same principles that Susan has more or less gone through. But I will quickly jump into how far is the law. It's 5 years down the road. This will be a 6th year. How far has the law gone as far as its implementation is concerned? Like I mentioned, regulations came around in 2021 to operationalize the law, and we must give the government credit for that. A regulatory authority was established called the Personal Data Protection Office. It was divorced from the National Information Technology Authority, which is an authority that regulates technology in Uganda. So we must again credit government for that. What has PDPO done, or even before it, when it was still part of NITA, which is the National Information Technology Authority? PDPO, and again, to add voice to what Susan earlier said, we're the ones to feed this authority. all these authorities, which are more or less courts of first instance when it comes to data protection matters. It's not enough for us to always cast the blame on them and say they're doing nothing. When we as lawyers, advocates, or generally as citizens of East Africa are sitting back. So what has the authority done? The authority has so far dealt with two high-profile matters. Of course, beyond what it has been doing, and I must credit it, going around creating awareness. I think it has even sponsored a moot competition in the university, among others. So beyond that awareness and ensuring, for example, companies, especially the multilaterals, or the big corporates have data protection officers, there have been two major investigations and all decisions that have come out of it. The first one concerns a company called Safe Border. I believe Safe Border was at some point in Kenya. I don't know if it managed to make it to Tanzania. It is basically a ride-hailing company, or what perhaps, I don't know if Swahili is the same word across border, that was running borders in Uganda and Kenya, and I think even Nigeria. Through a ride-hailing system or app, in other words, create a platform for people to be able to connect with borders. So what happens? I think there's a civil society organization called Unwanted Witness, which released a report that Safe Border had been selling or even transferring the personal data of its users to a third party without their consent, or even without carrying out regulatory impact assessments as per the law, data protection impact assessments as per the law. And someone latched onto that and filed a complaint with NITA. Then PDPO was still under NITA. NITA is the, like I mentioned earlier, the regulator of technology in Uganda. So PDPO then was still a department within NITA before it became independent. The investigation indeed found out that information was being shared with a third party without the consent of the customers or even users of the Safe Border app. And it released quite interesting findings, which I thought at the time were really going to be monumental as far as the data protection legal regime in Uganda is concerned. And I don't know whether indeed, since that investigative report, whether Ugandans, whether companies have since even had a chance to read it, but also followed through with compliance regarding many of the recommendations that came through. So from the drafting of the privacy policy that was on the Safe Border app, they realized that it was lacking in many aspects. And this becomes very important for us as lawyers, as advocates, as far as advising our clients is concerned, on how to properly draft a privacy policy. It's not enough for you to say, we have a privacy policy, and that's enough. Your data, we comply with the Data Protection Act, among others. No, you must show, for example, if it's about sharing information with a third party, where that information is going. And even if it's about sharing information with a third party, you must allow the users or your customers to be able to consent to that through proper consent mechanisms. Not enough for them to just tick a box, as long as they've clicked accept, and that is enough. You must have proper mechanisms in place as far as responses or incidents to data breaches are concerned. You must have, you must create a platform, or I know it's in line with the law, and many of our laws have that, but our data subjects should be able to have proper access requests where they think they want to know how you're using their data. If I gave you data last week, I want to know access, how I've used my data. I want to see where it has gone. What are you doing with it? So things like those. So it was quite an interesting report. And for as far as I'm concerned, is the report that should be instructive going forward. And I would encourage every lawyer to have a look at it and ensure that when they're drafting or advising their clients as far as data protection is concerned, they can be able to properly follow some of the recommendations there. As far as things like appropriate security measures should be in place, properly put in place obligations. If it's, for example, Now, the agreement between SafeBorder and that third party organization, which I think is called CleverTap, was also investigated, and NITA then, which became PDPO, realized that it was not compliant with the law, especially as far as properly putting in place obligations regarding security measures, the requirements for CleverTap to notify SafeBorder before engaging any other sub-processors, how to handle shared data, among others. So I'd encourage all of us to read it. It's online, you can access that report. So that was the first investigation. And my major takeaway from it would be ethical handling of data. It's not enough for you as a company to think that, hey, and of course in line with the law, that we have, as long as our clients have given us consent, that we can go ahead and do anything with it. So that becomes very, very important. And also you as a lawyer, I know, yes, you want to advise your clients and make money without having, I mean, if you perhaps as open with them and told them that the data protection legal regime is very strict, you scare them and run away. So for me, that report, please, everyone take time and read it. It was a very good report, I thought. So there was another investigation of the Uganda Securities Exchange. So it was discovered there had been a breach again, and with another partner. There was a breach. Then in the breach, after the breach was reported, NITA investigated the operations of a Uganda Security Exchange with one of its partners, which they believed was where all the problems came from. Again, in discovering the kind of arrangement that Uganda Securities Exchange had with this partner, they realized many lapses or many shortfalls as far as the data protection legal regime is concerned. I think in the maintenance agreement, it was not a proper maintenance agreement. It did not have, I think it has now become part and parcel of boilerplate clauses as far as drafting of contracts are concerned, that you must have clauses on data protection and security. So there's not even a clause like that in the agreement. The people they had put in charge of supervising and overseeing the agreement were not properly qualified. And that brings into place the aspect of qualifications. Well, thankfully, webinars like this go a long way, but also there are increasingly many courses that have developed as far as giving you bespoke knowledge or skills regarding data protection, things that show you how to properly carry out an data protection impact assessment, among others. So get skilled. So these people are not skilled. In other words, they didn't have proper data protection officers. So I found so many things, but again, importantly, the agreements or the arrangements between the two were not compliant with the law as far as data protection and security is concerned, as far as ensuring that the right people were in charge of overseeing that kind of arrangement. Yeah, so those have been the two major investigations, but we have a regulator in place, like I mentioned earlier. And increasingly, I'm aware there are some cases in court. Some cases were determined before the coming into force of the law, and were determined on rights under the Constitution of right to privacy, among others. But I'm aware there are some cases in court which have not been determined, and we're looking forward to decisions coming out of that. But slowly, the big corporates especially have tried to put their houses in order. For some reason, PDPO has majorly targeted them, which I think is also a bit of a problem. But here, you can't blame them. Maybe there is a target audience. They have a target audience right now in the short term of the large taxpayers. But I know for a fact that if anything, under the act, just about everyone is more or less a data processor or even controller, especially in law firms, the kind of data that we had on behalf of our clients. But I know for a fact that there are very few compliant law firms in Uganda, and that could be a problem. The day the PDPO decides to go for all of us will be a major problem. So for me, it's a developing area. 5 years is a bit too long as compared to what the Office of the Data Protection Commissioner is doing in Kenya. And for me, again, I must credit Kenyans for always being ahead of us in just about everything. I mean, I see a decision just about every 2 weeks. So, but again, like I mentioned earlier, perhaps we Ugandans or even East Africans should do a bigger job of bringing to the attention some of these issues. So thank you very much, Dorothy. I don't know if I've answered everything.
Yes, you have, Ivan, and thank you very much for going into the practical aspect of what is really going on in Uganda. It has given us a glimpse of how far you guys are doing in Uganda. And in particular, you stated about having like ethical handling of data. You spoke about ethical handling of data and how we as advocates need to advise our clients, because you can just draft something, you can draft a policy, but whatever you've done is not sufficient to cover your client. So thank you very much for that. And I'll have just one question for you before anything or before you proceed. I want to know, like, with the rise of AI, data, and digital innovation, what roles does technology play in strengthening or threatening data protection efforts in Uganda? Can you kindly enlighten us on that?
Thank you very much. What you've just told me brings to my mind something called cross-border data flows. Cross-border data flows, I think, are important because of the nature of technology. For example, a technology company, like I mentioned earlier, SafeBorder, is in about 4 or 5 jurisdictions. Jumia is almost all over the whole of Africa. Among others, all these fintechs. So meaning we should, as much as possible, encourage them to have their data moving around in order to ensure that e-commerce develops, and among others. But it's a balancing act, because in as much as we want this data to flow and help in the development of innovative tech platforms, among others, in as far as we want e-commerce development, as far as we want trade market access to develop and open up the borders, especially now that we have the African Continental Free Trade Area, which is looking at a digital Africa. We have to balance this with something called ensuring that we have strict legal regimes concerning cross-border data flows. Uganda's legal regime, for example, has a casual way of talking about it and says that if you're going to process data outside the jurisdictions of Uganda, ensure that the country that the data is going to has adequate protections in place, what is called adequacy in data protection. But for example, like we mentioned here, in South Sudan, we're not sure about the data protection legal regime there, or even Burundi. Thankfully, we have a Burundi person who's going to tell us. So this for me now calls into play one thing and one thing only. What is happening at the continental level? It is now beyond jurisdiction. It is beyond our individual countries. Data protection becomes a continental, regional integration, Pan-African thing. What do we have as far as Africa is concerned? We have something called the Malabo Convention. The Malabo Convention for a very long time took long to come into force. It just came into force, I think, last year or the other year. But even it's a bit casual on this. I've seen the AFCFTA digital protocol, and even if it's a bit casual, it does not create binding obligations. Like is the usual for many of these arguments, by the way. Many of the international trade agreements, as far as data protection is concerned, don't create binding obligations. So for me, that becomes a challenge, because if, yes, we want to promote technology, but at the same time, these guys are mining our data. There's a lot of data they're playing around with. As you saw recently in the TikTok case, it came to our attention that actually the algorithm that is run by behind TikTok, and the AI that runs the algorithm of TikTok is owned by ByteDance, which ByteDance is a Chinese company. And China demands that, these companies have somehow allowed government to control their technology at the back end. So this becomes a problem for us, because we don't have control over these things, and yet we are talking about data protection. So it becomes a bigger problem than we can handle. So perhaps Africa should stamp its foot regarding data protection and cross-border data flows in order for us to properly tap into the digital economy very well. So I don't know if I've answered the question.
Yes, thank you very much, Ivan, for quite an insightful reply to that. And let me now welcome Mr. Eve Sangano to speak about data protection laws in Rwanda and the role of advocates specifically in data breach cases. Mr. Eve, welcome for like 10 minutes. Give us an insight of what it is like in Rwanda.
Yeah, thank you, Dorothy. As of the Rwandan perspective, I can say that the data protection, the right to privacy, is a fundamental right preserved in our constitution. The right to privacy is complex, but a fundamental aspect of it, increasingly relevant to people's rights, is the protection of individual data. Increasingly, everything we do generate data, whether we have a device or not. Our device, network, and even home generate vast amount of data. Our transport system, cars, payment system, and cities also generate data among others. Then it is essential that obligation of those processing data are clear so that they take measures to protect personal data, mitigate interference with the right to privacy, and are held accountable when they fail to comply with obligations. This is particularly the case when it comes to our personal data. As a power Rwandan data protection law, personal data is processed electronically or by another means. The law provides ground for collecting and processing personal data, safeguards required for processing personal data, including sensitive data. And the general rules applicable for collecting and processing personal data. It provides the right to data subject and punishment for failure to comply with the laws requirement by those who either collect or process data. As a background, our legal framework is quite new, and before 2020, we used to have some provision different laws, but they were not enough to protect data as per the new regulation that we do have since 2021. Previously, we used to have a law relating to access to information, the law governing information and communication technologies, and some implementation tools from those laws, but they were not enough for having a clear legal framework. Since 2021, the Rwandan has enacted a new data protection law, and it has been as sorry, I had an internet issue. The regulatory body for this law is the National Cybersecurity Authority. This institution has been created since 2017, but it has been operationalized in 2020. The current status is that, of course, we do have this law, and in order to help people to comply with the law has given 2 years transitional period for organization and different companies to comply with it. This deadline the deadline was on 15 October 2023. However, we still have so many companies that are processing data without being registered. Awareness is being conducted so that everyone can be compliant with the new data protection law. The key provision that we have in our laws, of course, the first one is the consent that has been emphasized so that before any data can be processed, the data subject has to be constructed and should be freely give his consent for a specific for the data to be processed for a specific reason. And also, the law has specified that this consent can be given in different forms, being oral, written, or in electronic form. The ground for processing data, the law is clear that before you can ask the consent from the data subject, the ground for processing the data should be with illegal, one, meaning that processing data is permitted based on several grounds, based on contractual necessity, legal obligation, protection of virtual interest, public interest. That's but the main purpose is to make sure that it is a legitimate interest before you can process the data from a subject. Also, as has been explained by the presenters, the data subject who has the right to request the rectification of the data, objecting on processing its data. The data subject still have a control on the data he has shared with the controller or the processor, even if he has been given the consent to process his data. The supervisory authority for data protection in Rwanda also has the mandate to be notified in case of violation of data, of personal data. As per the law, in case of breach, in case of data, personal data breach, the data controller must communicate the breach with the National Cybersecurity Authority within 48 hours and must give a report, a detailed report on the same within 72 hours. The report should clearly specify the nature of the personal data breach, including where possible the categories and the approximate number of data subjects concerned, and the categories and the approximate number of person data recorded. It has to have there is a number of information that has to be provided. Another aspect, principle that we can mention is the data localization. The Rwandan law is mandatory that any data, any personal data must be hosted here in Rwanda. If you want to host the personal data outside the Rwanda, you should be given first the consent from the data subject. Then the supervisory authority has also to allows you to share or to host the data, the personal data from the data subject located in Rwanda to transfer those data outside the Rwanda. Also, the data retention is an aspect that has been discussed. Also, the law allows the retention of personal data until the purpose of processing personal data are fulfilled. This retention can be for a longer period if it is authorized by the law. When people or data subject or data controller are not complying with the law gives fine up to 5% of the annual turnover of the previous financial year and the cancellation of their right to process personal data. You understand that this is a huge sanction, and this is the role of advocate to make sure that data processor and data controller that are located here in Rwanda make sure that they are fully compliant with the legal requirement. The Rwanda Cybersecurity Authority is the one responsible for settling conflicts that may arise regarding data privacy. Where a person data is compromised, he may submit a complaint to the regulatory authority with details of the breach, and also the regulatory authority can investigate first before he can mediate and impose penalties on the offending party. If you look at the alignment with the Rwandan law with international standard, at the African level, our data protection law is aligned with the African Union Convention on the Cybersecurity and Personal Data Protection. which was adopted in Marabo, is in Equatorial Guinea. It is compliant with the Organization for Economic Cooperation and Development, OECD, private framework, and also Africa Continent Free Trade Area, which was signed in Kigali. In addition to that, the Rwanda Data Protection Law draws inspiration from the European Union General Data Protection Regulation. However, the Rwandan Data Protection Law goes further than the European Union General Data Protection Regulation, in that it does not limit its extraterritorial scope to processing activity related to offering of good or service and the monitoring of data subject behavior taking place in Rwanda. Consequently, organizations with non-presence or equipment in Rwanda, but that possess small or large number of volume of personal data collected from individuals in Rwanda would need to comply with this, the Rwandan law. If you consider the ethical consideration in personal data protection in our legal professional, we can specify that there is some dilemmas but that are being faced by legal professionals in handling personal data. Some of them we have identified that there is an issue of balancing confidentiality with the legal obligations. The legal professionals are bounded by attorney-client privilege, requiring them to keep client information confidential. However, as per the Rwandan law, we are mandated to report in case there is a breach of the data, personal data that we are hosting, and complying with any investigation that may be initiated by the regulatory authority, which somehow can become a dilemma as it may compromise our professional, the confidentiality in our professional. Then there is an access to sensitive information. We handle sensitive personal data such as health record, financial details, and so forth. And we have to ensure that those information is used only for its intended purpose and not mishandled can be posed a challenge, especially when we are in public hearing. Sometimes we may end up by exposing personal data from our client because, as you know, all the court hearings are being held publicly. Then there is a conflict between data privacy laws and cross-border practices. International cases may involve jurisdiction with conflicting data privacy law, creating uncertainty about how personal data should be handled. As an instance, like this could be where a legal professional representing an international company has to decide whether to transfer personal data to a country with a weaker data protection law, potentially violating strict home country laws and the regulation. Even sometimes we may forget that before we share those information, we have to be given the authorization from the regulatory authority, because when you are having personal data, you are not allowed to share those information outside the country without the formal authorization from the regulatory authority.
Sorry,
The standard.
Sorry to interrupt you, Mr. Sangano, but that was very insightful. I don't mean to interrupt you, but I really wish that we could also dive into the, like, what roles do advocates play in data breach cases in Rwanda? So as you're continuing with that, also you can also let us know and enlighten us on that aspect. Thank you.
Thank you. Of course, the legal professional are essential guiding organization to navigate the complexities of data protection law and the regulation, both local and international. We We do have expertise to ensure that business, government, and individuals comply with the legal obligations, protect the personal data, and mitigate risk of the legal liabilities. Our roles include advising on compliance, drafting internal policies, privacy notices, and contracts that comply with the local international standards. When data breach occur, advocates we take some steps, immediate access of the case, and also we advise on breach notification requirements as in accordance with the Rwandan law. As I mentioned, the data processor to have like 48 hours to report. We make sure that we work with the organization to minimize further harms and prevent recurrence on the data protection. Also, as we know, the emerging technologies like artificial intelligence and other revolutionary and those tools are revolutioning how data is being collected, processed, and stored. Those technologies offer significant benefits, but also introduce new challenges and risk concerning privacy and data protection. The advocate can leverage technologies in various ways to enhance privacy protection for individuals and organizations. They can use these tools to safeguard personal data, ensure compliance with private laws, and advocate for more sustained private rights. We can utilize data protection management tools to assist clients in maintaining ongoing compliance with private laws. We can use, of course, those AI tools, analyze privacy policies, contract, and agreements to ensure they comply with the privacy law. Artificial intelligence can identify gaps in privacy protection and help draft more robust contract. We do have so much that we can do so that we can play a key role in data protection. Thank you.
Thank you so much, Mr. Sangano. That was very mind-blowing. It's very amazing to know that most of these African jurisdictions, we have almost the same things. And in particular on the cross-border data transfer. Maybe later on, I would love to hear from you more on how practical is it? Like, yes, there are things to be done before you do that, but in Rwanda, like, is it really practical, and to what extent is it practical? But in the meantime, let me welcome Mr. Joseph Nuwamanya from Mawala Advocates in Tanzania to discuss Tanzania's data protection legal landscape and compliance challenges. Mr. Nuwamanya, karibu.
Asante sana, Dorothy. Good afternoon to you, and good afternoon to everyone this webinar. I understand the scope of what I have to discuss is the legal landscape, the data protection legal landscape for Tanzania, for starters, as well as the regulatory and compliance challenges that come with it. And I believe that should cover what is required of me. I'll be specific to Tanzania, if you allow me, because that's what's specifically now. I have also noted from the presentations that most of what we have in terms of the legal landscape in Tanzania is quite very similar to what we have in other East African counterparts. I would want to start off by saying that on our legal landscape, Tanzania has borrowed mainly or a lot from the European Union General Data Protection Regulations, the GDPR, as well as the Malabo Convention, which is the African Union Cybersecurity and Personal Data Protection, which was passed in 2014, but only finally assented to, I believe, a couple of years ago. So our current regulations, which is the Personal Data Protection Act, was passed in 2022. And that's behind most of our counterparts, at least not in the case of Burundi and South Sudan, but at least we are behind Kenya, Uganda, and Rwanda in that order. And I suppose we've learned a lot from their experiences in coming up with the legal landscape. But prior to having the Personal Data Protection Act, like I mentioned, we had quite other laws that affected, or rather protected, personal data. The first of which, of course, is the most important one, which is our Constitution. Like Ivan mentioned, most of all rights and guarantees with respect to privacy and personal security and data are enshrined in the Constitution. So our Article 16 of the Constitution provides that guarantee. It states that every person is entitled to respect and protection of their personal and privacy in their own person, their family, and that of their matrimonial life, and with respect to protection of their residence and private communication. So that is the enshrining aspect of personal data. But we also had other regulations prior to the Personal Data Protection Act, which came in 2022. We had such laws as the Cyber Crimes Act, Electronic Transactions Act, the National Payment Systems Act, and other sectoral regulations, some about finance, others about telecommunication. So those were in play, but the Personal Data Protection Act is the only law that we have that is very specific to this subject of data protection. So along with the Personal Data Protection Act, we do have pertinent regulations, and we have two main specific ones. The first being the Personal Data Protection, then Personal Data Collection and Processing Regulations. So that's the first regulation that was passed last in 2023, as well as the second being the Personal Data Protection, which is Complaints and Settlement Procedure Regulations. So basically those laws in totality establish principles for data protection and also set the minimum requirements for the collection, processing of personal data, as well as complaints settlement procedure. In addition to that, we also have other institutions that come along with the personal data protection laws, and these institutions, which also form part of the regulatory framework, include the Personal Data Protection Commission. This is also created, it's an act, it's a statutory body created under the Personal Data Protection Act, but also all this aspect of data protection comes from the government through the Ministry of Information, Communications and Information Technology. And then also we want to add that our courts in Tanzania are also part of the process, especially when it comes to dispute resolutions and settlement of any claims that may arise from breaches of personal data. At this point, I would want to talk about the principles of personal data protection. And like I said at the beginning, having sought inspiration from both the Malabo Convention as well as the GDPR, the Personal Data Protection Act in Tanzania is also shares inspiration from the principles that have been set out in those respective papers or documentation. Just as a highlight, the main principles that we have are that data protection has to be done for lawful, fair, and transparent reasons. There has to be a purpose limitation, meaning, like Susan explained prior, that you cannot collect data having informed the data subject that you're collecting it for reason A, while you actually intended to use it for reason B. But also another principle is that of data minimization, meaning that you only collect what you need. Okay, like was mentioned, do not collect, ask someone's tribe if you actually do not need that kind of information. Then there's the principle of accuracy and timeliness. You should always ensure that data that you collect is up to date. So there should be policies in place to ensure that the data is updated and accurate most of the time, rather at all times. Then there's the principle of storage limitation, meaning that data should not be stored for longer than necessary, but it is intended to be stored for. Then we have data subject rights. That's a principle. Will allow me to look into that a bit later, slightly. And then the principle of data security. And of course, the most common issue that has been resounding in these presentations, which is the transporter data transfers. Just then I talked about data subject rights. And we have from the laws and regulations, we can pick out a few data subject rights for in the Tanzanian legal landscape. And this includes a right to access personal data. So if a data subject issues information to a data processor or manager, then that person, the data subject, has a right to go and access and ask for that information. I think Susan alluded to that before. And then the data subjects also have a right to prevent processing likely to affect a data subject. So if a data subject feels that the data provided may affect them in any way, then they have a right to request for the suspension of such processing using any means whatsoever. And then also the right to prevent processing personal data for direct marketing purposes. That's also another aspect quite clear. And then right in relation to automated decisions, we all know what's happening with AI and how it can be categorized and set up and your data to be used by AI for any other reason. So the data subjects have a right not to have such automated, their data to be used in such automated systems, and then also right to compensation if the rights are violated. And then they also have a right to rectification, blocking, erasure, and destruction of personal data. So you have a right, not apart, in addition to accessing the data, but the data subject also has a right to have or ask and demand that their data be deleted. Allow me to talk about the Data Protection Commission. This is established under law, like I mentioned before. And this commission has roles of registering data protection collectors as well as processors, and it also has the power to handle complaints. It has the power, it's the first step for handling complaints in the event of data breaches. So basically it was, this commission has been established. It has started work, quite fairly new. I believe it has teething issues, which we'll talk about in a minute, but it is there at least as part of the framework of the legal framework. Of course, we also, like I mentioned before, we have the Minister for Information and Technology and Communications. And this ministry comes into play here because it's the specific ministry that through which the regulator falls, but also the minister's decision also has the power to receive appeals from some appeals from decisions made by the Commission. And then, of course, we have our courts, starting with High Court. And not any other court, we go to the High Court with respect to matters that come from this. So before I go to the regulatory and compliance challenges, allow me to delve more about in the law. The law was passed in 2022, like we said, 2.5 years old, and it has already been put to test. We have a famous case in Tanzania called the Tito Magoti versus the Honorable Attorney General, who challenged quite a number, who challenged 13 sections of the Personal Data Protection Act on grounds of it not being constitutional on so many levels. It's quite an interesting aspect, quite an interesting case that I would encourage everyone, especially practicing in Tanzania, to read. But ultimately, the outcome of the courts, interestingly, for a new law here in Tanzania was that at least 2 sections were found to be vague, and the court made an order that to the Attorney General, that is in May 2024, to have those respective sections to be amended within a period of 12 months, which ran out in May 2025, or else which they will be considered struck off from the Act. The specific provisions here are the Section 22 sub 3, which criminalizes collecting of personal data through unlawful means. So it was found that the definition of unlawful was not properly defined, and that was subject to abuse. And so that was also, on that reason, the court found it to be ambiguous. But also the court was of the opinion that during data collection, the exemptions given to data controllers being exempted from collecting data, personal data from the data subjects themselves in certain circumstances also unambiguous, and thought that would have been challenged. So that aspect has also been sent back to the Attorney General for amendment to have more specific provisions set out. But apart from these two, if we go back to all the other sections that were challenged, you can see that there's a repeat of a lot of unambiguous, rather a lot of ambiguous provisions, or provisions that are subject to abuse. And I think, and I hope that when the Attorney General, if should they respond to this order of the court, they should not just look at the 2 sections that the court was of the opinion were ambiguous, but rather all the aspects of this. So with that legal landscape, allow me to look at the challenges coming from the regulatory compliance.
Yes,
so,
3 minutes.
Good, I'm about done, thanks. So the biggest challenge I would put on the table for Tanzania is that this is basically a new law, and not just a new law, but it is a new concept. Most of us have been used to giving up our data as data subjects. We don't even know that as data subjects we have rights, but also data collectors, data controllers who've been running businesses which collect data do not know of this requirement and how it should be. So I know and I understand a lot of awareness has been going on, but I don't think it has been properly welcomed, because perhaps it comes as an expense to most of those that have been collecting data, but also I understand for some it would be they really need the data to promote their businesses, or perhaps they're passing on data to other people. But the other challenge I would say is, like I mentioned in the case, there's a lot of ambiguous sections or or rather provisions of the law that are subject to abuse or perhaps not even understanding. So that also poses a challenge, especially for lawyers, on how do you tell someone that that is unlawful? What is the limit? Where do you start and where do you end? So I think that's another challenge in terms of compliance. But personally, I've not come across a number of well-trained and authorities, people who understand the subject of data protection in Tanzania, to be able to help all institutions and companies and entities that have to deal with data collection and processing and storage. And this ranges from lawyers, from IT personnel within entities. So that, I think, is the biggest challenge, but is also a big challenge. But the biggest challenge is the lack of knowledge. And as per data shared by the Data Protection Commission, there were only 20 complaints in this jurisdiction. I think by the end of last year, just about 20 of data breaches that had been reported to be resolved. So that does allow me to end there, unless if you have question for me.
Thank you very much, Joseph. Thank you for diving into the challenges. And I think, as you highlighted, since also most of the laws are almost the same, also the challenges could also be more or less the same across the region. So I'll get back to you later, but for the time being, let me invite Mr. Clara Nigarura from Rubea and Co Advocates, DLA Piper, Burundi, to give us an insight of data protection laws in Burundi and ethical considerations in handling personal data. So welcome, Mr. Nigarura.
Thank you very much, Dorothy. I'm happy to be here. In Burundi, we don't have yet a specific Data Protection Act, but we'll find some provision about data protection in different laws, in different sectors, like the telecom sector, like the health sector, like the banking and the finance, like our Employment Act. So you understand that we don't also have a data protection authority because we don't have yet a law. So some clients will deal with the data protection laws of other jurisdictions, like the European directive that is applicable at some extent in different countries, but also some clients will apply some principles of best practice as a businesses, because, as I said, it is an ethical issue. It is about human rights. So I can agree that it's very challenging when you don't have a law. It's difficult to know what will be the limits in terms of data protection, in terms of storage, in terms of transfer. Basically, that is the situation in Burundi, but we hope that a specific law will be enacted soon. But when waiting for that law, we normally advise clients to look at the best practices around the world to try to be ahead of the time, because we know that very soon we'll get an act on data protection. So on the role of lawyers, I think we have a big role to play in policy and the laws drafting. For example, in my country where there is no law, it will be the task of lawyers to work on the policy, to work on the law. And in jurisdictions where there is law, there is a scope of assisting clients on compliance when they are drafting their guideline, when they are putting in place procedures. I think the role of advocates is critical. And also as a data processor, collector, we also have to comply. I think it's also important. I have followed the panelists and I found that many countries do have data protection laws in this region, and I was thinking if it is necessary or advisable to have like an East African community bill, or if it is not necessary to look at the different laws and harmonize, because if we are talking about the free movement of people, if we are talking about the free movement of services and goods, I think also it is important to look at which extent it is possible to see the free movement of data, or at least having an harmonized framework. So I can stop there to give time to questions or panelists. In brief, we are navigating the absence of the law and trying to do our best and assist clients to apply the best practices they can learn from other jurisdictions and other companies. Thank you very much, Dorothy.
You're welcome. Thank you so much for your presentation. I mean, it's very exciting to know that some of the things are pretty much the same. And of course, what you said about harmonization brings us to one of the questions that I would really love to ask Ms. Susan Nelima. As we see that there are some East African countries which have laws in place already, and there are some other countries which do not have the law in place. And in the end of the day, free movement of people and trade, and you have people like in Burundi, some decide to use the GDPR, of which you could be having, like if there was harmony within the region, it would be easier to use something that is more localized and more in accordance to our situation in East Africa. So Ms. Nelima, kindly, can you please try to explain to what extent are the regional data protection laws harmonized, and where do we see significant differences? At least we have a clue on that. Welcome.
Thank you, Dorothy, for that question. We cannot say there is zero extent. From the East African community, we confirmed that there's a framework of guidelines, and they have efforts in place to harmonize the laws. So it's a work in progress, but there is no a harmonized law yet. And those initiatives that are in place, according to ESC, may not be, it's a work in progress. So it might not come up now, but I know it's a work in progress. That's what they confirmed. And this is something they're working on, and they plan to have a working group from each member state so that they can come up with this harmonization. Albeit that there will be challenges, of course, to harmonize this, considering that some of the member states don't have the laws in place, but I'm sure they'll find a way of navigating that. And if you speak of significant differences, just from Mr. Clover, we've heard that Burundi has no a law in place, a dedicated law in place yet. And then we have these other member states that have a dedicated legislations in place. And then from Mr. Sangano, I also pick out a difference on issue of data localization. They have a strict data localization requirement. You must have a certificate of authorization in Rwanda for you to store data outside Rwanda. But then when you look at these other laws, there are less stringent rules on on authorization when it comes to where you're going to store your data if it's not in the country. And then, of course, sector application. Certain countries have applied data protection laws differently. For example, Kenya. They say Kenya has regulations for the public sector and for the private sector. But when you look at Tanzania, it's comprehensive and it covers both the public and the private sector. And then another difference is, of course, the yardsticks that are put in terms of cross-border data transfer. It's all different in different legislation. So yes, thank you. That is all I can say about the extent of harmonization and the significant differences.
Thank you so much, Susan. And we are hopeful, we're very, very hopeful that this harmonization bears some fruits eventually. And maybe coming to Rwanda, you've also indicated the case of Rwanda on localization strictness. And I wanted to know, like from Mr. Sangano, how practical is it to transfer data outside Rwanda? Like, okay, the law is there are rules that are placed on what needs to be done so as to transfer data outside Rwanda. But then how practical is it, Mr. Sangano?
Yeah, thank you. I would say that the first step before even you can apply to the regulatory authority for you to be given the authorization to transfer data outside Rwanda is to make sure that you receive the consent from the data subject that allows you to host its data or to transfer its personal data outside the Rwanda. That is the first step. Then you make that application together with those consents, and also what the regulatory authority will look at especially is how we have to indicate how those data will be hosted outside the Rwanda. You have to show that the minimum requirement on how data has to be hosted, or minimum data has to be protected, it will be respected. In general, I would say that I have never seen in the application we have managed to process for those especially companies intending to transfer data outside of Rwanda, those consent were given because they have managed to demonstrate how the data will continue to be protected outside Rwanda. Thank you.
Thank you so much. Now, before I release you, I would love to ask you another question, as in, if you have any notable cases in Rwanda, do you have any where there has been maybe legal representation that was crucial in addressing a data privacy violation? Can you share if you have any case in Rwanda?
Yeah, thank you. It is unfortunate that we don't have some specific case. Maybe especially it is because we still have our data protection law is still new, as it has been enacted in October 2021. However, there are some studies or some regulatory sanction that happened. If I can maybe give some of the two among those ones, like a study that has been conducted in 2023, which evaluated the potential risk of the privacy violation in manual collection of personal data during the COVID-19 pandemic in Rwanda. It has been, this study examined the risk associated with the manual collection and also how storing data on cloud platform, which were not hosted here in Rwanda. Of course, this happened even before the new law on data protection is in place, and the study has recommended a large-scale research and government support to improve data protection practice and providing employee trainings, developing internal policies, securing data storage, and also promoting citizen awareness on data protection law and privacy violation, because it has been revealed that people are not aware on how their data are being protected. At the regulatory level, a case that is well known here in Rwanda, it's something that happened in 2017, where MTN Rwanda has been fined, has been given a fine of 7 billion 30 million Rwandan franc. At that time, it was around 8 million point five USD because of non-compliance with the regulatory requirement for hosting personal data outside Rwanda, because they were hosting their IT services in Uganda, which was outside the Rwanda. MTN had to report to regulatory authority, and they have a hearing session that happened with MTN officials, and they have also admitted those facts, and RURA, the regulatory authority, has been given to them those findings. This is what I can give as an example. We don't, in court of law, as of now, we don't have cases in relation to data protection violation that I've seen. Thank you.
Thank you so much for your reply, Mr. Sangano. That was well replied, and we've understood how it is in Rwanda. So may I take this opportunity to invite Mr. Nuamanya for a few questions with regards to the Tanzania law. I want to understand first if the law currently, if the authority has, if the law grants power to the authority, the commission, to issue sanctions and fines. And also you spoke about, Mr. Nuamanya, you spoke about the way once there is an issue, the first place for the complaint to go is to the commission, and then I think the second step is to the High Court. How not confusing is that? Because as lawyers, we usually love to go to court. So can you please share any, something on that regard, Mr. Joseph Nuamanya?
Thank you very much, Dorothy. Yes, the law, the Data Protection, Personal Data Protection Act does provide sanctions in the event of breach of any of its provisions, like we mentioned in the case or in instance of unlawful data collection. And I believe, I can't remember exact figures, but they're quite small. I think it ranges from about 1 million to 100,000 TZS, which is $50, I would say, for those outside Tanzania, all the way to 5 million, I believe, which is about $2,000. But it also has, in certain instances, punishment by incarceration or prison. And I think in certain instances, both, either of the two or both. So I believe those, that is one of those. And then two, yes, the second aspect is, yes, it's confusing. We have a case in Tanzania, I believe, let me find that quite quickly. But I think that was the case of Fatuna someone whereby the court was of the opinion that that was also last year in March, I believe, whereby someone went directly to court, but the court was of the opinion that the commission was empowered to handle all complaints. But then also some parts of the law, I can't remember exactly where, which give power to the High Court to handle matters which have come from the commission, yet some other matters have to go to the minister. I believe that is also one of the confusing aspects of the law. I hope that answers your question, Dorothy.
Yes, you have. Also want to know how can businesses really and legal professionals navigate the complexities of compliance while maintaining operational efficiency? It is obvious that the compliance matters are very complex. So I would love to know from your end, like, what do you think businesses and legal professionals, how can they navigate the complexities and while they maintain their operational efficiency?
So this is quite a difficult one, yet easy. How do you keep compliant, but yet navigate or keep doing your business? First of all, I think the policy should be full compliance. All the time, any business that wants to stay healthy should always comply. The reason is that the potential consequences of non-compliance are usually heavy company. Such consequences include heavy fines. You've heard of the $8.5 million fine on MTN in Rwanda, but there's been other instances in Spain and other countries whereby entities that took data for other purposes without disclosing what purposes they were for, they were asked to pay about over about $20+ million. And I think in other countries, especially in the West, the fines are quite more hefty. But the other repercussion for non-compliance would be, especially if you're brought to such trials, would be reputational damage. If we know your company is, or an entity is actually indeed not compliant with data protection, something that we're sensitive about, especially going back to what Susan had initially presented, then that would come with a lot of reputational damage. But also the costs, apart from the heavy fines, the cost of litigating such matters would also be hefty under certain circumstances. So having looked at the potential consequences of non-compliance, then I think companies have to accept that this has come. It is a law and they have to fully comply. But then what do they do to be able to comply? I think this is what we should be answering actually. I think the first thing should be to, first of all, get competent people, get competent personnel, both legal, both IT, but also trained and competent data protection officers, or whatever title those people may be given in respective jurisdiction, to be able to understand the requirements for a particular business in terms of data complying with the respective law. And then following which they should be able to set up, and this is the second point for me, is to set up a data protection policies and systems in-house, so that all people employed within such entities are fully aware of such requirements and also comply with those respective policies and systems in place. That, I believe, would, there's no way around it, Dorothy, to be precise. You have to comply. However much you may complain that compliance is hard or could have issues, but I believe with steps in place, with systems in place, anyone should eventually be compliant. But also, most importantly, for the policies, there should be systems to mitigate data breaches. and how to mitigate the losses that may subsequently come from such data breaches.
All
And
right.
basically, that's just about it. Thanks, Dorothy.
Thank you so much, Mr. Joseph. And I think before we open at least for a question or two from the floor, maybe I would love to know, like what are the emerging ethical dilemmas do we foresee in data protection as technology advances? And I'll direct this question to Mr. Clever Nigarura from Burundi. Like, we're talking about ethics, we're talking about data protection and privacy to be also something that is ethical. So do we have any ethical dilemmas that we foresee in data protection as technology advances?
Thank you very much, Dorothy. I think the management of data is between the protection of the privacy, but also the running of the business. The dilemma I can foresee is about the costs. It also includes costs. I can think of some small startups, and I can think about the need for policies, guideline, technical aspect of it. And we have to look at this dilemma and protect the human rights, but also allow the business to move and not necessarily copy and paste laws and the policies taken from somewhere. So that one dilemma I can see directly. Of course, I am of the view that it's very important to protect the privacy, but I am also the view that it will be a tremendous task for some small companies in the region. Thank you very much.
Thank you, Mr. Clever. Now I wish to go to the audience for a while, and maybe there is a question or two apart from those which have been already answered. I've seen a question from Godfrey Lutaya, and I think this has been answered by Mr. Joseph on whether the Tanzania law grants power to issue fines and sanctions. So let me pick up like two questions and then for my panelists to answer, and then we can wind up the session. Okay, so we have a question from Christopher. He says there have been online reports of data leaks in Kenya affecting public institutions like the company's registry. What recommendations would you make for managing this? Okay, I think though this is a case in Kenya, but considering the fact that these laws cut across, maybe Ms. Susan, can you try to answer these questions? Like, we're talking about leaking of documents in the registries, recommendations, of course, on top of what we already have. Do you have anything that you can add on that?
Dorothy, I'm just looking for that question. There have been online reports of data leaks in Kenya affecting public institutions like the company's registry. What recommendations would you make for managing this? So the recommendations basically, I'll just highlight some of the best practices that can help us avoid data leaks. First of all is to comply with the law, but some of the best practices actually derived from this law. And one of them is you have to do regular checks, and this is called regular audits. I mean, some of the companies you can learn from that have already developed data protection laws usually have recommended quarterly checks, and those who have the muscle actually do monthly audits to ensure that their online portals are secured from any data leaks. And then another best practice that we can put in place as public institutions or private institutions, it applies to both, is to encrypt your data. And with encryption, I mean that you have data and then it only appears right to the person you share it with. If it reaches a person that is not supposed to have that data, usually it's obscured. They can't see anything. It shows itself like it's a virus that has attacked the document. So they won't see exactly what it is. So there are these technologies which ensure encryption of data. So in data, we mean data at rest that is in your office or institution, and data that you are transferring outside your institution. So secure the data at rest and the data that is on transit through encryption. And then the other best practice I could think of is, of course, we spoke about data minimization. You don't collect unnecessary data and store it. You become a target of the cyber crimes or cyber criminals, and you become also a target of these hackers. So I think end there. These are some of the best practices, yeah, and recommendations.
Thank you
Yeah.
so much. That is very well put and well elaborated. Actually, it is what we need to do to have those best practices in the companies that we are working with or we are advising. So I think there are no more questions, and with that, allow me to wind up the session. But before I welcome Mr. Gabriel to proceed and wind up, we've seen that throughout our discussions, data protection is not just about legal obligation, but also ethical responsibility. And it requires continuous adaptation to technological advancements, also to regulatory changes, as well as the evolving needs of individuals and businesses. And I've seen that our panelists have very much highlighted diverse legal framework across East Africa. This area of framework was very well covered by all of them. And the compliance challenges that organizations face have also been covered, and the essential role of advocates in guiding businesses, representing individuals, and influencing policy development and regulations development. And one of the most crucial points we've discussed today is that privacy is a fundamental right. And you can see an example of Tanzania. It is even in the constitution as a basic human rights, right to privacy. And as legal professionals, we must ensure that data protection laws are not only enforced, but also interpreted in a way that safeguards this right. So as advocates, you are supposed to continue to provide strategic legal guidance and to support regulatory compliance and to uphold ethical standards in handling personal data. So as we move forward, it is evident that we need collaboration between legal practitioners, regulators, businesses, and policymakers, so as to get a harmonized and effective data protection framework across the region. And the role of advocates will only become more critical in ensuring that data privacy remains a priority, because right now it is a very fast evolving digital era and we cannot run away from that. And I would like to sincerely thank our esteemed panelists for their valuable insights and our audience for their participation and engagement. I hope this conversation has provided you with the new perspectives and practical takeaways that you can apply in your respective fields. Thank you all, and I look forward to further discussions on this important topic. Back to you, Gabriel. Gabriel? Do you have anything as we wind up the session?
Yes, certainly, Dorothy. It's been a very impactful and insightful session. And on behalf of the Secretariat, I would like to say thank you for your participation and your insightful contributions today, colleagues. As we've seen today, it's indeed a settled score that advocates play an essential role in safeguarding personal data and privacy rights while ensuring that legal frameworks are effectively implemented and that ethical standards are upheld. The challenges we face today in East Africa are both complex and urgent, requiring a coordinated effort from all of us. So as we move forward, I encourage us to remain not only committed, but to understand the evolving landscape. Let's keep researching, let's keep learning, and yeah, let's keep exploring, let's keep discussing. So as we conclude, I would like to also interest you in another webinar session happening on Thursday, the 6th of February 2025, and we'll be discussing competition law, and we'll be looking at competition law and competition practices, trying to understand and underscore different principles in competition law and consumer protection within the region. And we do have a very well-composed panel of experts from the COMESA Competition Authority, from the Competition Authority of Kenya, Fidelis Institute, and a number of competition law and consumer protection practitioners. So I do encourage you to register for that session, and we look forward to hosting you. To you, our esteemed panelists, Susan, Dorothy, Clever, Yves, and Joseph, and Ivan, who left earlier, we want to say thank you, thank you, thank you. We cannot thank you enough, and always feel free to join us in future events. And to you, our partners from Hilton, Attorneys, ALN, Rwanda, DLA Piper, Burundi, and all those who have been on this platform, we want to say thank you. You have yourselves a very blessed afternoon. A recording will be shared alongside certificates of attendance to you, our participants, and a certificate of appreciation to you, our esteemed panelists. So until we meet again on Thursday, stay blessed, and we remain committed to serving you. Goodbye.